Hi, everyone, and welcome back to Probate Notes. I'm your host, Sam Price, California probate attorney and certified specialist in estate planning, trust, and probate law. Today's episode is all about one of the most common and misunderstood aspects of probate: selling real estate. We're going to walk through the full process step by step, from the moment the personal representative is appointed by the court and receives letters, all the way through listing the property, accepting an offer, navigating the notice or court confirmation process, and finally closing escrow and handling the sales proceeds. Whether you're an attorney, fiduciary, paralegal, or real estate agent, this episode will give you a clear picture of how probate real estate sales really work in California and how to avoid costly mistakes that can delay the case. I'll share practice tips, common pitfalls, and what the court and buyers expect at each step. So, whether you're guiding a client or managing your own workflow, you'll walk away with practical tools to move the transaction forward confidently. Let's get started. So, the first thing that we want to know in a probate sale is whether or not a probate attorney is needed. So, when the owner of real estate passes away, if there's someone else that has the right to survivorship, then we don't need to go through a probate matter. So, for example, if we have Harry Smith and Wendy Smith, husband and wife, as joint tenants, so long as that joint tenancy is not severed, if Harry passes away, then his half of the property will go to Wendy, and a probate case is not needed. That's the same thing when you have community property with right of survivorship. If you have Harry Smith and Wendy Smith, husband and wife, as community property with right of survivorship, that also gives the right of survivorship so long as it's not severed. So if you have one surviving joint tenant or someone with the right of survivorship alive that owns the property, then a probate case is not needed. When you do need a probate case is when you only have one individual owner of real estate. So that is, if one person owns the property and they passed away, you're going to need a probate matter. And if you have more than one owner of the property, but they're tenants in common, so it might say something like Simon Smith and Debbie Johnson as tenants in common, then there's no right to survivorship. And then if one of them passed away, if Simon passed away, then there would have to be a probate matter for Simon's ownership interest in the property. And tenants in common is the default in California. So if there's no vesting after a couple of people's names, if it just says Simon Smith and Debbie Johnson, then they are tenants in common if they don't have any vesting after their name that says joint tenants or something like that. So many people want to know, what is probate? And probate is a court procedure where a judge appoints a personal representative of an estate and administers that estate. And during that probate matter, the house can be sold or the property can be sold. And so that process involves, I, as an attorney, get a client. If the owner of real estate has passed away, then I prepare a petition for probate to appoint my client as the personal representative of the estate. Sometimes we call that personal representative the executor because there's a will and the will nominates that person to be the executor. Or sometimes they're called the administrator with will annexed. So when it comes to listing a house for sale, if we have a personal representative with letters, whether or not that person has full authority or limited authority makes a difference. If I have a personal representative with full authority under the Independent Administration of Estates Act, then the listing can be made by that personal representative. Now, they can only list it for up to 90 days. They don't have authority to list it for more than 90 days at a time. And the listing agreement cannot have an automatic renewal after that 90-day period. And if the property is listed for more than 270 days, then the personal representative must send out a notice of proposed action in order to renew the listing agreement. And that listing agreement should say that the sale is subject to court confirmation or is conducted under the Independent Administration of States Act and notice of proposed action is given. Now, even if a notice of proposed action is given, as we're about to learn in a bit, court confirmation could be required if there are any objections to the sale. The disclosure requirements of the Civil Code exempts probate sales from the statutory requirements of disclosure. That's the transfer disclosure statement or natural hazard disclosure statement that have to be given. So probate sales are exempt from that. Now, under the listing agreement, the commission cannot exceed the amount the court will allow, and the sale has to be as is with no warranties except for a warranty of title. That's if someone has full authority. If our personal representative has limited authority, then it's the same terms. However, with limited authority, the personal representative must seek court approval before entering into a listing agreement for an exclusive listing agreement to sell the real estate for no more than 90 days. And so each time I can go in, usually with an ex parte petition, requesting the court to approve for the personal representative with limited authority to enter into a listing agreement. But if the listing lasts more than 270 days, not only do we have to seek court approval to list the property, but we also have to show that it's in the best interest of the estate to continue to list that property with that broker. We have to publish in the newspaper at least 3 times advertising the sale of the property. We have to post a notification in the court. The court clerk does that. And we have to give out written notice to all interested parties about the court confirmation of sale. And then we actually have a court hearing with an auction. And once we get an order confirming the sale, then we can go ahead and close the escrow. So for the court confirmation of sale, if that's required, that's either if the personal representative has limited authority under the Independent Administration of Estates Act, or the personal representative has full authority and someone has objected to the sale, then in either of those instances, we have to go through a court confirmation of sale process. Now, when you sell something through a court confirmation, the sale price must be within 90% of the appraised value of the property, unless there's some good reason why it's less than that. Now, the appraisal itself has to be have a valuation date within the past year. Usually, appraisals on an inventory and appraisal in a probate matter are all appraised as of the date of death. So the date of death valuation shows on the inventory and appraisal. Now, the appraisal must be through the probate referee. And so if that date of death is more than a year ago, then we must get a reappraisal for sale, a new appraisal. So that has to be within the past year. And in general, the buyer must put down at least 10% of the purchase price in order to purchase that property. Or they might have some good reason why they don't have 10% to put down on the property. It might be that they're getting FHA financing. They only have to put down as much as 5%. Or there could be some reason that the condition of the property, we've widely offered the property for sale and there hasn't been a buyer who would put at least 10% down. So there could be a reason why we don't have at least 10% down on the purchase price. So at the actual court hearing, there's an auction in open court, and the judge is the auctioneer. Now, they don't have to necessarily talk real fast like an auctioneer does, but they do have to see if there are anyone interested in bidding on the property.